ET Final Score is brought to you by Ashley Furniture.
Two felony indictments are dismissed. He signs a stipulation of evidence to one count, if I'm correct, of a misdemeanor indictment. There's not even an adjudication of that misdemeanor indictment, but under terms and conditions that you have devised within the authority that you have, that he reports to probation for a year of probation on pretrial diversion. And if he successfully completes the year of probation, then the motions for dismissal stand. The two felony indictments have been dismissed. He has not been adjudicated on the misdemeanor, and that's it. Is that correct? And I do not believe that to be an appropriate disposition of this case. And if I have seen other cases where it's been where that's been proposed to me, and I don't believe I have, I know I didn't see it as appropriate in those cases. To the best of my recollection, I have never approved any pretrial diversion in this court. And that's what this amounts to. I understand you've done your best to put it together. You've worked with Mr. Herring on it. I know with the best motives involved on both the part of you and Mr. Herring, but I see nothing here. In fact, I know that as Mr. Herring has referred to, Mr. Rust in the newspaper, Ms. Worchel's office on TV, has stated he did not commit these offenses. That's my recollection. I'm sure he's before the court today on arraignment on pleas of not guilty to all three of these cases. I don't consider these appropriate dispositions because this is not a matter where you're coming in before me. And when I say dispositions, I don't consider the motions to dismiss appropriate because there's basically no disposition involved. The motions to dismiss don't say anything about the evidence being insufficient or you being unable to prove any part of the case. They just asked me to dismiss two felony indictments because he has stipulated to committing one count of a misdemeanor indictment on which he's not adjudicated, and then he's put over on 1 year probation. I don't believe it's appropriate in this case. I believe that I'll put it to you this way. I'm not going to, when I say I'm not going to approve it, I'm not going to grant the motions to dismiss for the reasons stated in the motions to dismiss and what has been presented to me as exhibits, Mr. Larison, and explained to me by you in regard to the motions to dismiss. I do not believe it is appropriate. He's here on not guilty pleas. There is no indication from you whatsoever that the evidence is insufficient for you to go forward on these felony indictments or misdemeanor indictment. You have elected and agreed, you're going to honor your word on the question about it with us, defense, to present this to the court, which involve these motions to dismiss, and that's your decision to do that. It is my decision to deny the motions to dismiss. That's where we are. I am denying all three motions to dismiss. There's one in each cause number for the reasons that I have stated. I see nothing where you say the evidence is insufficient to support a conviction. Nothing where you say the evidence is insufficient for you to go to trial. Nothing of the sort where the evidence is insufficient, where it's insufficient to support a conviction, where you can't go forward because you've got witness problems. Whatever it may be. I mean, there's just simply nothing in these motions to dismiss to convince me that these motions to dismiss should be granted. There is nothing more here. There shouldn't say nothing more, but what this amounts to is a motion to dismiss two felony indictments, a stipulation of evidence to one count on a misdemeanor, for which under your agreement, Mr. Herring's agreement, which you certainly have the authority to enter into, he is placed on 1 year probation in a case that's not even adjudicated. Therefore, the three motions to dismiss, Mr. Larison, the court is going to deny each of your motions to dismiss in each one of those three cases, and the indictments will remain on the court's docket. They are set for Monday. I understand, Mr. Herring, you may have a problem with Monday in Austin. Can you tell me about that?
That problem has been resolved, Your Honor.
Then let me ask you, Mr. Larison, in regard to these 3 indictments, are you ready?
No, Your Honor.
All right.
And I'm not telling the court that I'm not ready for trial on Monday.
That's my question.
Other than that, I don't know that ethically I can go forward as the prosecutor.
That's a decision you'll have to make, and I suppose with Mr. Bingham's office, and obviously for the record, Mr. Bingham's office is not disqualified. You're not an attorney pro tem, as I understand it. Isn't that right, as a special prosecutor, Mr. Larison?
That's right, Your Honor.
All right, so that's beyond the court. That's a matter of what you elect to do. So I suppose I would imagine you would advise the court as soon as you can. They're on the docket for Monday, so the court would need to know as soon as you can advise me what your status is going to be. They will be on the docket.
Excuse me, Your Honor, would it be all right if we took a short break and discuss that and get back with you in just a couple of minutes?
Well, sure, that's fine. I was just trying to give Mr. Larison the time he needs, and I was thinking Mr. Herring was going to have to be in Austin Monday. But anyway, since that's been with Bobby, I'm glad to give you whatever time you need, Mr. Bobby.